Today I am going to cover the topic classification of contract. In the last lecture, we had discussed the essentials of valid contract, the 9 essentials, and today we will be covering classification of contract. The contracts are classified on the basis of validity, on the basis of formation, and on the basis of performance. Why this classification is necessary? To understand the legality of the contract or the extent to which the contract is enforceable, the classification is necessary and therefore the study is important. The first type is valid contract, a contract which has all the 9 essentials of a valid contract is known as fully enforceable contract, and the second is voidable contract. Voidable contract means a contract which is enforceable at the option of one of the parties but not at the option of other. Means a contract in which one of the parties has the right to avoid the contract but the other party does not have the right to avoid the contract. Such a contract is known as voidable contract. The situations where a contract is said to be voidable is when the consent of the parties is not free, or when a time limit is given for the performance of the contract and the contract is not performed within that time, or where one party is willing to perform the contract but the other party does not allow it to perform the contract. In such a situation, the aggrieved party has the right to break the contract. मतलब जब आपकी सहमति स्वेच्छा से दी हुई नहीं है या फिर जब समय पे कॉन्ट्रैक्ट परफॉर्म करने की बात है और वो कॉन्ट्रैक्ट को उस समय के अंदर सामने वाले ने परफॉर्म नहीं किया तो आप चाहें तो आप कॉन्ट्रैक्ट तोड़ सकते हैं। उसी तरीके से यदि आप कॉन्ट्रैक्ट परफॉर्म करना चाहते हैं लेकिन कोई और आपको कॉन्ट्रैक्ट परफॉर्म करने से रोकता है तो उस परिस्थिति में आप यदि चाहें तो आप कॉन्ट्रैक्ट तोड़ सकते हैं। ऐसे कॉन्ट्रैक्ट को हम वॉइडेबल कॉन्ट्रैक्ट कहते हैं। Then we come to the next type, that is void agreement. Void agreement is void ab initio. An agreement which is unenforceable from the very beginning is known as void agreement. In the last video, I had covered few situations in which the agreement is said to be void. Then the next type is void contract. A contract which is enforceable in the beginning but it ceases to be enforceable due to the change in the circumstances. Such a contract is known as void contract. Example, if you have entered into a contract with someone who is residing in a country with which our country is having war. In that situation, originally the contract was enforceable, but now because a country is having war with that country, an agreement with the residents of such country is void. Or suppose you have entered into an agreement with someone to deliver you some goods, but all of a sudden if that factory of that person is due to a bomb blast, it has been destroyed, so he is not in a position to deliver the goods. So then in that situation it is said that the contract is void contract. Then we come to illegal agreements. Actually, illegal agreements are void agreements, but the difference between illegal agreement and void agreement is that the collateral event related to illegal agreements will also be void. Any agreement which is against the provisions of law, it is illegal. The last is unenforceable contracts. Unenforceable contracts are the contracts which have all the 9 essentials of valid contract, but due to some technicality or some technical lacuna, the contract is not enforceable. But the moment that technical lacuna is overcome, the contract becomes enforceable. Such a contract is known as unenforceable contract. Like we can say that you want to take a SIM connection, right? And if you haven't given your photo ID or if you haven't given your address, so in that situation maybe your SIM won't be activated. So only that little bit of thing is remaining, और जैसे ही वो काम आप पूरा कर लेंगे तो वो कॉन्ट्रैक्ट पूरी तरीके से एनफोर्सेबल हो जाएगा. Then we come to the classification on the basis of formation. किस तरीके से कॉन्ट्रैक्ट बना उसके बेसिस पे ये क्लासिफिकेशन है. पहला है एक्सप्रेस्ड कॉन्ट्रैक्ट. एक्सप्रेस कॉन्ट्रैक्ट इज एंटर्ड इनटू बाय the expression between the parties, means the parties give the offer also and the acceptance also. This expressed contract can be oral or written. Like, I say I want to sell my pen and you say you are willing to purchase this pen. So this is an express contract. And as I said, there are two types. It can be oral or it can be written. Second is implied contract. Implied contract is a contract which is entered into by the conduct of the parties. Though means it's not necessary that the parties have expressed it, but by their behavior they communicate through non-verbal communication. We can say that the contract has been entered. Like, if you see a bus coming and stopping at the stop, and you enter it in the bus, I don't think that the ticket vendor will tell you that you will have to pay for the ticket, or you also won't ask the bus conductor that if I pay, will you properly drop me at my destination? It is implied. So by the behavior, the contract is entered into. And the next type is quasi-contract. Quasi-contract means semi-contract. Yesterday we had discussed that in a contract there are basically two ingredients, essential ingredients. They are agreement and legal enforceability. In case of quasi-contract, this important factor of agreement is missing. There is only legal enforceability. For example, if by mistake you take somebody else's property, like suppose in the class you take the register of someone else and you believe that it is yours and you start using that register. So here you have not entered into an agreement with the person whose register you have taken, but legal enforceability will be there. Means you will have to pay for the cost of the register. So this is quasi-contract. In the same way, if you find the lost property of someone, then you will try to search the true owner, and in this process, if you incur any expenditure, you have the right to recover the amount from the true owner. So though there is no agreement between you and the true owner, but still there will be legal enforceability. The true owner is bound to give you all the expenses incurred by you. Then the next type of contract is e-commerce. In this period of quarantine, you may be entering into n number of e-contracts. So any contract through electronic media or through mobile are known as e-commerce contract. Then the last classification is on the basis of performance. Performance means to the extent to which the contract has been performed, and on that basis the classifications are made. So the first is executed contract. Executed contract is a contract in which the parties have performed the contract. Happy ending, nothing remains to be done. And executory contract means the parties have not performed their obligations. In executory contract, we can say it is unilateral or bilateral. Unilateral means when one of the parties has performed the contract and the other party has still not performed the obligation, and bilateral is when both the parties have not performed their obligations. So this is the classification as per the Indian Contract Act. Unilateral contract is also known as contracts with executed consideration and bilateral contracts are known as contracts with executory consideration. In the English law, the classification is very simple. They are formal contracts, there are simple contracts. Formal contracts are contracts of record, and the second type is contracts under seal. But as per the Indian Contract Act, you have to understand these classifications. Thank you. If you wish that I need to cover any other topic, kindly mention it in the comment section. Kindly share and subscribe my channel. Stay tuned. Thank you.